public places, meaning not throughout the entire city, but in segments of the city. Laws prohibiting sleeping in public exist in 18% of cities for citywide bans. 27% of cities ban the activity or restrict it in particular places, such as in public parks. Begging in public, laws prohibiting that throughout the city are nearly a quarter at 24%. 76% of cities prohibit that activity in particular public places throughout. Laws prohibiting loitering, also known as loafing or vagrancy laws, have bans in the range of 33% for citywide bans and 65% of the prohibition on that activity in particular public places. Laws prohibiting sitting or lying down in public are criminalized in 53% of the cities that we surveyed. Laws prohibiting sleeping in vehicles exist in 43% of the cities that we surveyed. And laws prohibiting food sharing exist in 9% of the cities that we surveyed. We also looked at the increase or decrease of these types of criminalization laws. And what we found is that overall there has been an increase since our last report in 2011. There are a couple of slides that I'll go through very quickly here because we are going to talk about each category in more detail. But as you can see, there have been changes in bans related to activities in particular public places, a 60% increase on camping, and a slight decrease on loitering, and a decrease in sleeping in public. And while that may seem like good news, that good news is muted when you look at the dramatic increase in citywide bans. Bans on camping in public throughout an entire city have increased a whopping 60%. Bans on loitering, loafing, or vagrancy have increased by 35%. Bans on begging in public have increased by 25% from 2011 through June 2014. Let's discuss each of these categories of law in slightly more detail. As we just mentioned, there has been a dramatic increase in citywide bans of camping. It's often broad defined to encompass a wide range of living arrangements. In Minneapolis, Minnesota, for example, it is illegal for a homeless person to use, and I'm quoting, a camp car, a house trailer, automobile, tent, or other temporary structure, end quote, as temporary housing anywhere in the city. The effect of this law is to prohibit homeless people from using any resource that might be their only option for some shelter from the elements. Other cities go even further in their definition, criminalizing an even broader array of activities. In Clearwater, Florida, for example, you are prohibited under the definition of lodging outdoors from laying down a blanket or a sleeping bag or even cardboard for the purposes of sleeping. That activity runs afoul of their anti-camping ban. And in Orlando, Florida, the most broad interpretation is enforced, and that defines camping as including merely sleeping out of doors. I should note that these laws, particularly the citywide bans on camping, may be written to prohibit the activity on all public and private property within the city limits. This not only makes it illegal for homeless people to, quote-unquote, camp anywhere in the city, effectively creating a no-homeless zone, it can also subject private landowners to criminal liability when they choose to offer their property as a safe haven for homeless people. This has been an issue for some local churches who wish to use their property as a safe place for homeless people to sleep, but who are forbidden from doing so under local laws and subject to criminal liability if they violate those laws. Next, sleeping in public. As our chart shows, there has been no change in citywide bans on sleeping in public, no decrease, but there has been a decrease in bans on sleeping in particular places. This is the only category where there has not been some increase in the prevalence of criminalization laws since 2011. The decrease in sleeping laws may be attributable to the dramatic rise in anti-camping laws, which often cover the same conduct. As cities move to anti-camping laws that ban sleeping in both public and private locations, even when there are no more citywide bans on sleeping, and actually fewer bans on sleeping in particular public places, the overall problem of cities making it illegal to sleep outdoors is getting worse. And we provide a couple of examples, and there are additional examples of the laws in our prohibited conduct chart, which are included in the appendix of the report that you can access online. But for purposes of this webinar, a couple of highlighted examples are one from Manchester, New Hampshire, where it is illegal for a person to lounge or sleep in or upon any of the commons or squares of the city, banning sleeping outright throughout the city. Other laws prohibit sleeping during specific times of the day. In Virginia Beach, Virginia, for example, it is a crime for any person to sleep in any public park or in or on any other public property between the hours of 8 p.m. and 8 a.m. The impact on health and safety really cannot be overstated. Without a safe place to sleep, homeless people are under constant threat of arrest, and even if they're not cited or arrested for violating this law, they would be harassed and asked to move, which can cause a lack of any ability to rest, threatening the health of a homeless person on the street. That, combined with other factors related to living outdoors, can lead to medical problems that result in very costly medical interventions like treatment in emergency rooms. Begging in public, often also referred to as panhandling, has seen an increase since 2011. We've seen a quarter of the city's ad laws, a 25% increase in citywide bans, and 20% increase in bans on begging in particular places. And I've included some examples of different types of begging laws here. Some, like in Lexington, Kentucky, just place an outright ban on begging, forbidding it on any public street, and a violation of that law is punishable by a minimum of 10 days in jail. Other cities allow begging, but only under very strict conditions. In Springfield, Illinois, for example, only silent panhandling is permitted. It is unlawful to make any quote-unquote vocal appeal in which a person requests an immediate donation of money or other gratuity. That law is currently the subject of litigation as a violation of free speech rights. There are also laws aimed at preventing what is called aggressive panhandling, but these laws can be broadly defined to include activities that are devoid of any physical or verbal aggression. In Mobile, Alabama, for example, it is deemed aggressive panhandling if a person requests a donation from someone waiting at a bus stop. It is also aggressive panhandling if someone requests a donation after sunset. These laws ignore the fact that in the absence of employment opportunities, or when homeless people are unable to access needed public benefits, panhandling may be a person's only option for raising an income. Even in an area with a relatively robust homeless services network, homeless people still need access to cash to purchase food, clothing, personal hygiene products, to access public transportation, or even to pay for their stays in emergency shelters. I'd also note that somewhat uniquely among criminalization laws, restrictions on panhandling in particular places function very much like citywide bans. And this is because commercial and tourist districts, the areas where begging is most likely to be prohibited, are often the only places where homeless people have regular access to passers-by and potential donors. Another category of law that we look at, and a very common criminalization measure, are what we refer to as loitering, loafing, and vagrancy laws. And much like the others, they have experienced an increase since 2011. There's been a 35% increase in citywide bans on loitering since 2011, and there has been a slight decrease on those laws in particular public places, a 3% decrease. Loitering is also very broadly defined and used to criminalize innocuous activities of homeless people like sitting, standing still, or lying down. These laws may be written so broadly as to be subject to wide interpretation of what is or is not a crime. In the words of California homeless advocate Paul Bowden, what a city might call loitering, a homeless person calls standing still. An example is from Newport, Rhode Island, where it is illegal to, and I quote, remain idly in essentially one location, including the concepts of spending time idly, loafing, or standing about aimlessly, and also including the colloquial expression, hanging around, end quote. In Wichita, Kansas, it is illegal to linger, to stay, to saunter, to delay, or to stand around. Because homeless people do not have the luxury of a private place where they might rest, and rest they must, loitering laws subject a homeless person to criminal penalties anytime they choose to remain in one place for too long. Enforcement of anti-loitering laws often overlap with enforcement of municipal or state trespass laws, as a citation or arrest for loitering will often be accompanied by a warning not to return to the area or face arrest for trespass. And my colleague Kirsten Clanton will be speaking in more detail about the effect of trespass laws on the homeless population as well. Sitting and lying down in public. These laws are related to loitering laws in that they're also intended to address the movement of homeless people or lack thereof. However, these ones are often referred to as Sitlie Law since they usually explicitly address that conduct. And we've seen a dramatic rise in those laws of 43% since 2011. In Virginia Beach, as an example, it is unlawful for any person to sit, recline, or lie down on any street, sidewalk, alley, or curb throughout the entire city. Other laws restrict sitting or lying down during specific times of the day. In Denver, Colorado, for example, it is illegal and a crime for any person to sit down knowingly or lie down knowingly on the surface of a public right-of-way or upon any chair, stool, or other object that's been placed upon that surface between the hours of 7 a.m. and 9 p.m. These laws are often justified under the theories they are necessary to move idle homeless people out of sight to improve an area's economic activity. But a University of California at Berkeley School of Law research report on the issue found no empirical evidence to support that theory. In fact, quite the opposite. The report found that the Sitlie laws actually impose costs on local communities related to implementation and enforcement of the laws. Laws restricting or prohibiting living in vehicles experienced by far the most dramatic upswing since 2011. A 119% increase in laws prohibiting living in vehicles exists now that did not exist in 2011. One example is in El Cajon, California, where there's a citywide ban, and that law states in its entirety, no person shall use a vehicle while it is parked or standing upon any street or alley as either temporary or permanent living quarters, abode or place of habitation, either overnight or day by day. In Las Vegas, Nevada, you are forbidden from taking up temporary or permanent residence or to occupy for habitation for a time. You're not allowed to do those things in your car, but you are allowed to sleep. In other words, naps are okay, but using your vehicle as a temporary residence is not. This law has recently been subject to challenge, and the Ninth Circuit has recently invalidated a Los Angeles ban on living in vehicles in the case of Desertrain v. City of Los Angeles. In that case, the Ninth Circuit Court of Appeals found that the law provided insufficient notice of the conduct it penalizes and that it promoted arbitrary and discriminatory enforcement. Good precedent, like the Desertrain case, may have the effect of reversing the startling trend that our report reveals. I also want to note that these laws can be uniquely harmful in that they represent often a massive loss of belongings following an arrest. When someone is arrested for sleeping in a vehicle, oftentimes the vehicle, along with every other worldly possession of the homeless person, is impounded. And upon release from jail, that person is unable to afford the fee to remove their vehicle and their belongings from impound. Not only will they lose their vehicle, which often represents the most valuable asset that they own, but they also will lose all of their possessions, including ones that are difficult or perhaps impossible to replace, like photo identification, Social Security card, birth certificate, or needed medication. This creates other obvious barriers to transportation, potentially affecting employment, schooling, or other activities of homeless people. Food sharing laws. Eating is essential to life. We cannot survive without food, yet many cities have chosen to make it a crime for individuals, often members of faith-based organizations, to share food with homeless people. These laws are often justified under erroneous theories that free food enables or even encourages people to remain homeless. And sometimes these laws are justified as a public health measure, serving as something of a quality control over the food that homeless people eat. But these theories aren't supported by hard evidence or even by common sense. As we've discussed, the lack of affordable housing and a lack of shelter options cause homelessness, not the availability of free food. And the actual availability of food shouldn't be overestimated. Even where free food services are present in a community, increased demand for these services since the onset of the foreclosure crisis have left many food service providers with an inadequate supply to meet the growing need. Also, some food services are limited to specific times of the day or certain days of the week. Rather than protecting the health of homeless people, restricting access to food that may be shared by individuals or faith-based organizations, these laws force hungry people to search for food in potentially unsanitary places, like garbage cans. These laws also, similar to the camping laws, are an example of how the criminalization of homelessness can affect not only homeless people, but those who wish to help homeless people. Individuals or organizations who wish to engage in the simple act of feeding the hungry can be subject to criminal punishment in the form of fines or even jail time. One example of a food-sharing law exists in Dallas, Texas, and that was recently the subject of litigation brought by the National Law Center on Homelessness and Poverty, along with the law firm Aiken Gump, on behalf of two religious organizations in Dallas, Texas, challenging that city's law. The court found that food-sharing activities were religious expression protected under Texas law, and that the city had failed to articulate a compelling interest justifying the food-sharing restriction. At this time, I will turn it over to Kirsten Clanton, attorney and director of the Homeless Advocacy Project at Southern Legal Counsel, who will talk more about the potential illegality of criminalization laws. Kirsten?
Hi, thank you very much, Tristia. I'm going to focus a little bit on what's going on in Florida, partly because Florida presents a really nice case study of homelessness and creative ways to criminalize homelessness that unfortunately get exported to other areas of the country. Tristia, I don't have control of the PowerPoint. So the first thing I wanted to talk about was the fact that sleeping is criminalized, as Tristia spoke, in a lot of different communities, innocent and life-sustaining conduct. And what we've seen in Miami back in 1992 is that a district court there found that the city the homeless for harmless, involuntary life-sustaining acts such as sleeping, sitting, or eating in public is cruel and unusual. And that was in the Pottinger case, which is a famous case across the country. And the factual findings of the court in that case are pretty self-evident, but the idea is that since individuals rarely choose to be homeless and there's an unavailability of housing or shelter space, there's no choice for these homeless individuals to conduct this involuntary life-sustaining conduct in public. And therefore, the court found that it would violate the Eighth Amendment to arrest people for this conduct that arises out of their involuntary condition of being homeless. Another way in which sleeping ordinances violate the law is, and this was found in a Florida case, it was a City of St. Petersburg ordinance criminalizing sleeping in public, and they found that it was unconstitutional because it drew no distinction between conduct that was calculated to harm and that which was essentially innocent conduct. And that's what we see a lot of with these criminalizations. Yes.
I just wanted to let you know that there is a technical difficulty with turning the ability to switch the slides over to you, so please just let me know next slide, and I'll be following along so that I can switch them during your presentation.
Okay, thank you. And so, basically, the problem with, these sleeping ordinances is that cities are basically targeting this innocent behavior that's really, essential to people's lives. And, the courts have found that this is unconstitutional. Another thing about sleeping ordinances that's interesting is that in 2011, Orange County in Florida discussed whether to enact a camping ordinance, but they ultimately declined to do so because the mayor stated that homeless people don't have a choice about their situation, and the county did not want to just move the problem around. The city of Orlando is located in Orange County, and the sheriff of Orange County was previously the police chief, and he testified at the city commission meeting against enacting the ordinance because he said homelessness is really a social problem, it's not a police problem. And he noted that the camping ordinance in Orlando is no silver bullet for dealing with homelessness. Unfortunately, many other cities and counties came to the opposite conclusion and are continuing to press ahead with using this as a tool to address homelessness. With the issue of begging as protected speech, which is on the next slide, as you've seen, there's been a huge uptick in ordinances restricting begging and panhandling. But the interesting thing about begging is that it is protected speech under the First Amendment. And complete citywide bans on a particular method of speech is not constitutional. Although cities are continuing to pursue that strategy. From how my organization's been looking at this issue since 2010, we've seen more than 20 different Florida cities and counties adding new ordinances or amending prior ordinances restricting begging or panhandling. This is despite the fact that, for example, during a debate over a panhandling ordinance in West Palm Beach in 2010, the sheriff of Palm Beach County said, "Well, we cannot arrest our way out of this situation because all the people we take off the street corner are merely passing through the system and are back out on the street and they're not getting the help that they need." People, as Tristia mentioned earlier, people who panhandle because they have no money and are then arrested face criminal fines and court costs. For example, I have an arrest affidavit from an individual who was arrested in Florida in 2010 for panhandling. He served 45 days in jail and was assessed more than $2,500 in court costs and fines. When you have a situation where you're asking for spare change and wind up owing nearly $3,000, the ability for an individual to be able to escape the cycle of homelessness is made that much more challenging. So as you can see from this slide here, there's a tremendous amount of scrutiny that needs to be given to panhandling laws to ensure that they comply with the Constitution. And just as kind of an example, on the next slide, I have an example of an ordinance from Marion County that was actually challenged by our office, and we ended up getting an injunction. And I use this ordinance as an example because it violates the Constitution in pretty much every way a panhandling ordinance can violate the Constitution, so it's a good example. And one of the problems with this is that it discriminates based on the content of speech, and so it prohibits begging for your personal use, but it does not prohibit soliciting funds for a charitable organization, for example, or on behalf of someone else. And those violate both the First Amendment and equal protection. Another issue with this ordinance is that it's pretty vague and it lends itself to arbitrary and discriminatory enforcement. For example, neither the county nor the court knew exactly how a person would indirectly beg for money. Another issue with this ordinance is that it had a licensing scheme where you had to first apply for and ask permission to engage in protected speech. and there was no fee waiver available. You had to pay a $100 fee. So that was discriminatory. And then also you had to be issued a badge identifying you as a beggar. Again, the city could not identify any rational basis for requiring someone to wear a beggar's badge in order to engage in speech. So those are, some ideas of some of the constitutional problems that occur with these ordinances, but they are unfortunately continuing to increase. The next category that I wanted to discuss was loitering, loafing, and vagrancy ordinances. And these are, on the next slide, I'm talking about a City of Jacksonville ordinance that was declared unconstitutional by the U.S. Supreme Court back in 1972. And it criminalized a lot of the same behaviors that are continuing to be criminalized by cities across the country. Wandering or strolling around from place to place without any lawful purpose, or being a loafer. And these types of ordinances are struck down, as this one was, by the U.S. Supreme Court, because there is not adequate notice as to the difference between innocent and unlawful conduct. And since there's no standards governing the exercise of discretion granted to police, the ordinance, and then it permits arbitrary and discriminatory enforcement of the law. And the purpose of these kind of ordinances is to cast a broad net, to just allow police to decide who is lawfully standing on a city street and who is committing a crime. And actually, following up on what Tristia mentioned about the Desser Train case out of the city of Los Angeles, similar reasoning that the court discussed the Papa Cristo case at length in this Los Angeles case, and discussed the problem with not understanding the difference between regular conduct that people do in their cars every day, like eating food in a vehicle or keeping a sleeping bag in the car or speaking on a cell phone. And all of those were things that the plaintiffs had done that had gotten them cited and arrested. In fact, one of the plaintiffs was not even parked anywhere, but was driving on a city street when she was detained and arrested by the police for violating the anti-lodging ordinance in her vehicle. The court found that this broad and cryptic statute criminalizes innocent behavior, making it impossible for citizens to know how to keep their conduct within the pale. The next type of ordinance
I don't sound quite now. It's got to be them. I'll be back.
but also outside of the downtown district. But the case that Tristia mentioned earlier, the Big Heart Ministries versus City of Dallas, I think is a very interesting case, not just from the perspective of the legal analysis, but the court did a lot of discussion in there about how the city was basically trying to regulate feeding based on a lot of speculations and assumptions. And so one of them was that they thought that by restricting food, it would cause people who are service resistant to actually seek those services. And the expert of the plaintiffs had testified that that's not what would really occur, but that people would get food in more unsafe manners, such as in dumpsters or in other locations. And I think that that's an important point because I've seen a lot of discussion in Florida about cities and counties trying to eliminate food sharing by churches and or other organizations, both in public places and on their own property, because cities believe that feeding people enables them to be homeless, and if they're not being fed, that they would cease being homeless, which is really not rooted in reality in any research at all. The next is trespass, which is on the next slide. And that is really, when I'm talking about trespass, what I'm talking about is specifically using trespass warnings or exclusion orders or some sort of ban that is affirmatively restraining people from accessing public parks and buildings where they would otherwise lawfully be allowed to be. This is a really troubling trend because it turns mere physical presence in public places into a crime. And this picture is actually a photo of a particular city park in the city of St. Petersburg, where they have a trespass ordinance that allows them to ban people from city parks, even during the daytime when it would otherwise be open to the public. And on the next slide, I discuss a case that our organization actually brought along with the National Law Center on Homelessness and Poverty against the city of St. Petersburg. And that case was Catrone versus the city of St. Petersburg. And in that case, one of our plaintiffs was banned permanently from all city parks, and the other plaintiff was banned for a year from a city park based on an alleged violation of a city ordinance that he was never prosecuted for or criminally punished for. But there was no mechanism by which they could actually challenge their trespass warnings. And so we brought a due process claim in federal court, and the court ruled that our plaintiffs have a constitutionally protected liberty interest to be in parks or other city property of their choosing that are open to the public generally. So in other words, they don't have a right to go into a city building when it's closed or in a city park when it's closed, but during hours when it's open to the public, they have a right to be there. And if the city deprives them of that right by giving them trespass warnings, then they're required to provide due process. They're required to provide a mechanism by which they can challenge those trespass warnings. This is an important case because a lot of times the reason why these trespass policies can function is because they are arbitrary, because the police or city officials are picking and choosing and just using them as a tool to ban homeless people from public space. And if they have to actually give some sort of justification in front of an independent, impartial decision maker, then that reasoning starts to fall apart. The other thing I want to mention about banning people from city parks, it also raises First Amendment concerns. Our office currently has litigation against the city of St. Peter. Their trespass policy under the First Amendment was city parks are traditional public forums and natural places to exercise your First Amendment rights. It causes concerns when cities can ban you from being present in those places. The next thing I wanted to just mention is the issue of public urination laws. While those, and that's discussed on the next slide, while those laws, are kind of facially neutral in the sense that they seem to apply equally to everyone, for homeless people who do not have access to bathrooms, either private bathrooms or public ones, because most cities don't have publicly available restrooms 24 hours a day, 7 days a week, it causes tremendous difficulties. And one thing I just wanted to note is that in Pensacola, in 2013, the city there passed an ordinance prohibiting certain activities in city restrooms, things like bathing or washing up, mixing a drink, shaving, things like that were criminalized. And the city council members were discussing how it would prohibit one city council member from shaving in the bathroom. Another city council member was concerned it would be illegal to prepare a bottle of baby formula. And the police chief said, in response to those concerns, well, that the police have discretion and they would never arrest council members for shaving or making a protein drink in a bathroom. And that discussion highlights exactly the reason why these types of ordinances can be discriminatory. They give the police the discretion to decide when innocent conduct is a crime or when it is not. And a lot of times that depends on who's the person engaging in the conduct. And there's no consideration for the fact that a lot of homeless people have no choice but to take care of these basic needs in public. And then the last thing I wanted to mention is on the next slide, just talking a little bit about Pinellas County and criminalization there. The Law Center's report highlights Clearwater as an example of a city that's pursued a lot of criminalizing ordinances, and the city of St. Petersburg we've discussed as well and has appeared in past reports. And there has been such a problem with criminalization in Pinellas County that the sheriff himself actually opened his own homeless shelter that's actually on the jail property in an annex. And the good thing about the shelter is that it is low barrier and it costs less than housing people in the jail. But one of the challenges with the shelter is that the cities have used it as a tool to try to force people into the shelter while they're actively enforcing a wide variety of tools that the police officers have to arrest homeless people for any number of things. And the shelter itself has issues because, you have to earn your way into a bed by doing certain things, and if you violate rules, then you have to sleep outside. And it's far away from city centers, so it results in increased marginalization and isolation of homeless people. And I think it's sort of premised in this faulty idea that homelessness is a deviant behavior that needs to be modified because people are choosing to be poor and choosing to live outside. Kind of that at the root of a lot of these criminalization measures. And this idea that we can actually deter homelessness in some way by passing another camping ordinance or another panhandling ordinance. And if criminalization worked, Florida certainly would have managed to eradicate homelessness altogether because we've tried every which way to punish people for being homeless. And then the last slide I have here is just something that Tristia touched on, and it's a recent report from Central Florida that tells us what we already know, which is that the criminal justice system is a costly intervention to homelessness, and it costs significantly less money to house homeless people than to keep people locked in homelessness. And for both legal and policy reasons, homelessness and using those cost savings instead to end homelessness, which are a number in the millions of dollars, as you can see from this report. Thank you.
Thank you very much, Kirsten. That was great. You have Kirsten Clanton's contact information here on this slide. And again, this webinar is recorded and it will be made available on our website. Continuing on with where Kirsten let off, the expense of criminalization laws is something that is a very important point to consider. Kirsten went over how those laws are potentially illegal. These laws are always expensive. They are, in fact, the least effective and most expensive way to deal with homelessness in a community. And simply put, they waste limited state and local resources. Rather than addressing the root causes of homelessness, criminalization policies temporarily cycle homeless people through the costly criminal justice system, from the streets to the jail and then back to the streets, worsening the problem with each cycle. A growing body of research comparing the cost of homelessness, including expenses related to criminalization, with the cost of providing housing to homeless people consistently shows that housing homeless people, rather than jailing them, is the much more effective and affordable option. One example comes out of the state of Utah. In 2005, the Utah Housing and Community Development Division reported that the annual cost of emergency room visits and jail stays for an average homeless person in the state was $16,670, while providing each individual homeless person with their own apartment and the social work amounted to an annual cost of $11,000, representing nearly $6,000 in savings. In part motivated by the sensible cost effectiveness of pursuing a housing approach, Utah implemented a Housing First program that has allowed it to reduce its rate of chronic homelessness by a very impressive 74% since 2005, saving taxpayer dollars while achieving the goal of moving people off of the public streets. Another example comes from Albuquerque, New Mexico. A 2013 analysis by the University of New Mexico Institute for Social Research of a comparable housing program in Albuquerque, entitled the Heading Home Initiative, found that after only 1 year of the housing program's operation, the city of Albuquerque realized a savings of over $600,000. That represents nearly a 32% reduction in what was spent the year before the program went into effect. These savings resulted in part from a 64% reduction in costs related to jailing homeless people. Also, it's important to note that given the potential illegality of these laws, cities that criminalize homelessness may also expose themselves to potentially expensive litigation. And these laws are ineffective. They simply do not work. They do nothing to address the underlying causes of homelessness. And in fact, they perpetuate homelessness and make it that much more difficult to escape. And this is due in part to the collateral consequences of criminalization. One, it leaves homeless people with criminal records. And criminal records can have an effect on one's ability to obtain employment when they do record checks, a background check. It can leave somebody unable to rent an apartment in the private rental market as a result of their criminal record. It can also make someone ineligible under local policies from public housing authorities to receive the housing subsidies that they need to escape homelessness. Also, when someone is arrested, it may result in the loss of their personal belongings, including the loss of photo identification and other needed belongings to prove identity and to obtain employment, to obtain housing, to obtain public benefits. There also are numerous access to justice issues that are raised. A homeless person who is arrested, unable to afford standard bail, will often be given the choice of either accepting a criminal conviction on their record so that they can be released from incarceration, or being held in jail until they can resolve their matter before a judge. They will not be released on their own recognizance due to their lack of an address, and that can result in very lengthy and expensive time spent behind bars. Also, there are certain resolutions of cases that may not be available to a homeless person, again due to their lack of an address. For example, they may not be offered probation as a way to resolve their case because a probation officer would not have an address where they can monitor the homeless person. As a result, homeless people, in addition to being unable to pay the court costs and fees associated with their incarceration, may spend much longer time behind bars than counterparts who engage in the same conduct. Now that's all the bad news. The good news is there are constructive alternatives to criminalization. For all the reasons that we discussed today and more, discussed in more detail in our report, criminalization is not the answer to meeting the needs of cities that are concerned about homelessness in their communities. There are sensible, cost-effective, humane, constructive alternatives to criminalization, and government at all levels should take steps to pursue these strategies. The most important way to address homelessness is to increase the availability of affordable housing. While there are increasing examples of good models to maximize the use of existing housing resources, without additional investment at a scale needed to end current homelessness, even the best models will be unable to solve the problem and to prevent future homelessness. So where do you get the resources for additional affordable housing? Well, one is through funding the National Housing Trust Fund. That fund was enacted as part of the Housing and Economic Recovery Act of 2008. It's a block grant to states administered by HUD. Distribution is at the state level, and it's based on the priority housing needs of the given state. But the law requires that 90% of the money be used to preserve, rehabilitate, or operate rental housing for very low-income and extremely low-income households. To date, the National Housing Trust Fund has received no funding. Although federal law requires Fannie Mae and Freddie Mac to contribute a percentage of their revenue to finance the fund, these contributions were suspended before they were ever made when Fannie and Freddie began losing money in the wake of the foreclosure crisis. Fannie Mae and Freddie Mac are, again, profitable, however. Rather than all of those profits going into the federal treasury, Fannie Mae and Freddie Mac should make their required contributions to the National Housing Trust Fund as required by federal law. Providing as much as $3.5 billion per year in funding to the National Housing Trust Fund is also included in a bipartisan housing finance reform bill introduced in March of this year by Senate Banking Committee Chair Tim Johnson, who's a Democrat from South Dakota, and Ranking Member Mike Crapo, a Republican from Idaho. State and local governments should also dedicate sources of funding to housing and homeless services. One example of a dedicated funding source that has proved successful is found in Miami-Dade County. It's the Miami-Dade County Homeless and Domestic Violence Tax. The tax provides a dedicated revenue stream for homeless services from a 1% tax on all food and beverage sales by certain restaurants. These funds raise almost $20 million a year, helping to fund emergency, supportive, and transitional housing and other homeless services within Miami-Dade County. In addition to new resources, it's important for cities to improve the efficient and effective service delivery of existing resources. And one method for achieving this is by implementing a housing-first model. The housing-first approach is premised on the idea that pairing homeless people with immediate access to their own apartments, supplemented with any needed supportive services, is the best way to address homelessness. And the model has been highly successful, not only reducing homelessness, but also in saving taxpayer dollars. One example, as we discussed, is found in Utah. Utah developed a highly successful housing-first model, in part by creating a centralized tenant selection process that pairs people in need with available housing resources in an efficient and timely manner. And as a result, Utah has realized a 74% reduction in chronic homelessness. Another example of improved coordination of existing services is found in the 25 Cities Initiative, launched as a partnership between Community Solutions, which is the group that launched the highly successful 100,000 Homes campaign, HUD, the VA, and the United States Interagency Council on Homelessness. The program will help eliminate the need for homeless people to jump through multiple bureaucratic hoops before receiving services, helping to get people the services they need without the same risk that they will fall through the cracks. And in the interest of time, I know that we're running out of time here. I'm going to move very quickly through the last few examples. It's important for communities to improve police training and practices. Criminalization laws represent a misuse of police power, not just because they divert resources from true threats to public safety, but also because it turns police officers into part of the problem rather than a critical part of the solution. Police officers can be, once they're properly trained and engaged constructively, can serve as a very important part of the solution, and that is seen in the development and implementation of street outreach teams, where police officers can serve as key members of the teams, or they may coordinate with teams that are comprised of local service providers or healthcare professionals. The report goes into more detail, but one model that we highlight is the street outreach team operating in Houston, Texas. That team has the stated goal of helping chronically homeless people obtain housing. It's comprised of a sergeant, 2 police officers, and 1 mental health professional, and they have successfully collaborated with Houston homeless service providers to help local residents access needed resources from housing to bus fare. Another method is to improve transition planning from jails and hospitals. People released from incarceration face a very high likelihood of experiencing homelessness, which can lead to recidivism and to unhealthy communities. Assisting with a transition plan while someone is in custody is another constructive way of reducing homelessness and thereby reducing any incentive to criminalize homelessness. Transition planning from hospitals is also very important. According to the Journal of General Internal Medicine, 60% of homeless patients spent their first night after hospital discharge in a shelter, and 11% spent it on the street. With no safe place to rest or store medication or to access sanitation, medical recovery is undermined, and many end up right back in the hospital at taxpayer expense. Some local communities, like Philadelphia, Pennsylvania, have developed respite centers in recognition of the problem, allowing a homeless person a place to recuperate upon release from a hospital or clinic. But there is much more to be done. First, the federal government has a responsibility to combat the criminalization of homelessness, and our report outlines several different recommendations to the Department of Housing and Urban Development, the Department of Justice, and the Federal Housing Finance Administration. In the interest of time, I won't go over these in detail, but what we do recommend is that federal dollars not be freely flowing to communities that use them to criminalize homelessness, whether those be McKinney-Vento dollars from HUD or community policing grants from DOJ, and instead, those federal funds should be directed toward communities that are implementing constructive alternatives. We also make recommendations to state and local governments. State governments should enact and enforce Homeless Bill of Rights legislation that prohibits the criminalization of homelessness by local communities. And local communities should, of course, immediately cease enforcement of criminalization laws, repeal those laws, and stop enacting new criminalization laws, and instead pursue constructive alternatives to criminalization. My contact information is here, and I do want to thank everyone for staying with us, even though we are a bit over time. I would ask your indulgence for just a few more minutes while we launch the poll questions that I told you about at the beginning of the webinar. And right now, we are going to be launching our first poll question, which is, as a result of this webinar, do you have a better understanding of the criminalization of homelessness? And I'll give people a few moments to answer. I don't know if you guys can see on your screens what I'm seeing on mine, but it looks like the result is overwhelmingly yes, but 98% are answering that they do have a better understanding. We'll now launch the second poll question. And that question is, are you likely to use the information that you learned today in your work? And I'll give everyone a moment to answer that as well. Okay, it looks like the results are coming in, and 72% of you have voted. I'll give you just a few more moments here, but I am encouraged to see that right now, 94% of you have stated that you will be able to use this information in your work, and we're very pleased about that. The Law Center, as I said, has both this recorded webinar as well as the report with more detail about what we discussed today, and a prohibited conduct chart with live links directly to places in each city's codes where you can find the criminalization laws that we reviewed, available on our website at www.nlchp.org. I want to thank everyone today for staying with us over time. I apologize that we weren't able to get to some of your questions. I want to encourage everyone to reach out to me with any of the questions they have about this webinar or about the criminalization of homelessness. We look forward to hearing from you. Thank you all very much and have a great afternoon.
I talked to Tricia before.
Want to cut this taping off?
Yeah. We're done.
I'll let you do it.